Hello everyone, this is a short webinar on the history of war crimes trials. Let's start with the historical origins of war crimes trials. The first recorded international trial for the commission of war crimes took place in 1474. Peter von Hagenbach, the German knight, was put before a tribunal of knights who came from the neighboring city-state of the region for the conduct of his troops for the atrocities committed by his troops while him being in the service of the Duke of Burgundy. Peter von Hagenbach was convicted and sentenced to death. With the advent of the state sovereignty in the 17th century, states had the exclusive power and authority of deciding on the matters which took place within their own borders, including how their own citizens were to be treated. With the late 19th century came the first codification, the first regulation of the laws and customs of war. The laws and customs of war regulate the conduct of hostilities, that is, how the rules of armed conflict are to take place in the scenario that we have an armed conflict between two or more states. Therefore, how are soldiers to behave? How are members belonging to the armed forces of the states are to behave? This is regulated by the laws and customs of war, which are collectively known as international humanitarian law. Initially, violations of international humanitarian law only generated the responsibility of the state. They did not result in the trial and conviction of people for the commission of those crimes. Gradually, though, breaches of international humanitarian law came to be considered as constituting war crimes and therefore as giving rise to individual criminal responsibility, to the responsibility of specific individuals for the commission of international crimes. The turning point in the establishment and development of war crimes trials came with the Second World War and the atrocities committed during the Second World War. The scale and the gravity of the atrocities led to the creation of two international tribunals at the end of the war. In 1945, the International Military Tribunal of Nuremberg was established, the IMT. The IMT was set up to try the greatest Nazi criminals. In the other side of the world, a year later or so, the International Military Tribunal for the Far East, otherwise called the Tokyo Tribunal, was established. The Tokyo Tribunal, its purpose was to try Japanese crimes committed in Southeast Asia during World War II. These two tribunals, their findings were pivotal for the establishment of individual criminal responsibility and the effective recognition of war crimes trials as the means by which to bring to justice the individuals responsible for the commission of war crimes. What did the Nuremberg Tribunal say? It said the following: crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced. Therefore, individuals could no longer hide behind the curtain of the state, behind the state entity, the abstract state entity. Crimes were committed by people, by specific people. Therefore, those people had to be brought to justice in order for the provisions of international law to be enforced. The Nuremberg and Tokyo tribunals tried three separate crimes. These were, in the first place, crimes against peace. Crimes against peace today is called the crime of aggression. It is a crime of initiating, of planning a war of aggression against another country. Also, we had the trial of individuals for war crimes. War crimes are the violations of the laws or customs of war. When we talk about war crimes trials, it may be a bit misleading that they are only dealing with war crimes. No, this is not exactly the case. War crimes tribunals deal with war crimes, but they may also deal with other crimes. These being, for example, crimes against peace and crimes against humanity. Crimes against humanity are specifically designed to protect the civilian population from being attacked. Therefore, the original definition of crimes against humanity in the Nuremberg and Tokyo Charter referred to the crimes of murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population. Therefore, crimes against humanity are there to deal with attacks against the civilian population. War crimes, on the other hand, they do protect attacks against civilians, but they also provide for the protection of other categories of individuals and objects deemed to merit protection. For example, prisoners of war are entitled to protection. Civilians are entitled to protection. Children are entitled to a special type of protection. Also, what do we mean by objects which are entitled to protection? Buildings of culture, churches, mosques, these are objects which are entitled to protection, and if they're attacked, destroyed, or damaged, this is a violation of the wars, of the customs of war. So let's let's discuss a bit about the legacy of the Nuremberg and Tokyo tribunals. For the first time in history, international criminal justice prevailed over political expediency. And this effectively ended the monopoly of states for the prosecution or non-prosecution of war crimes. New offenses were also made punishable. These were crimes against peace and crimes against humanity. Up until 1945, the only international crimes which were actually brought before courts were war crimes, which stem from international humanitarian law. Also, another innovative element of these tribunals. Up until that stage, only people who belonged to the armed forces had ever been prosecuted. Now, for the first time in history, we have military leaders being brought to justice, and also prominent civilians who had a role to play in carrying out and supporting the war. For example, prominent politicians, industrialists were brought to justice before the Nuremberg tribunal. On the downside, though, these tribunals were criticized because they essentially imposed victor's justice. They were established, they were created by the victorious parties to the conflict in order to try the state and the individuals who came from those states who had effectively lost the war. Now, this brings into play questions of selective justice, of one-sided justice, and also of ignoring the crimes allegedly committed by the victorious countries. What happened after the Nuremberg and Tokyo tribunals finished their work? Now, after the end of the World War II trials, there was no much activity taking place. There was pauses in the prosecution of war criminals. On the international level, there was no trial at all. And on the national level, there were very few trials taking place before national courts. At the same time, though, several significant treaties which related to international crimes were concluded. For example, we have the 1949 Geneva Convention, which regulate the laws and customs of war, and there are additional protocols adopted in 1977. And also, very importantly, in 1948, we had the Genocide Convention coming into force. The convention which prohibited the crime of genocide. After a pause of several decades, the 1990s brought about renowned activity in the area of war crimes trials. What did take place in the 1990s? Unfortunately, in the first place, we had the outbreak of violent conflicts, which led to the widespread loss of life and widespread commission of violence against thousands and hundreds of thousands of people. As a result, we had in the first place the establishment of two tribunals, of two ad hoc tribunals in former Yugoslavia and Rwanda to bring to justice the individuals which were responsible for the commission of crimes during these two very violent conflicts. The first one was the conflict which came about with the disintegration of former Yugoslavia, and secondly, the ethnic conflict which took place in Rwanda in the 1990s. The Tribunal of the former Yugoslavia was established in The Hague, while the Tribunal, the International Criminal Tribunal for Rwanda, was established in Tanzania. So we had renowned activity in the last decade of the previous century and during the first decade of the 21st century. What was special about these tribunals? Now, the first two tribunals, the ad hoc tribunals, were the ICTY and the ICTR. They were international tribunals in that they were established by the United Nations Security Council to deal with the conflicts which took place in the former Yugoslavia and Rwanda. Why are they called ad hoc tribunals? They were called ad hoc tribunals because they were established for a specific purpose, for a specific conflict, and upon the completion of their work, they would cease to exist, and they did so a few years ago. Subsequently, we had the establishment of additional tribunals also being ad hoc. These were the hybrid and international tribunals, most of which were established in the first decade of the 21st century. Now, these tribunals were also ad hoc in that they were established for a specific purpose, for a specific conflict, for a specific situation, and they will, with the purpose of ceasing to exist upon the completion of their mandate. Some prominent examples are the Special Court of Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, the Special Tribunal for Lebanon, and so on. Now, as opposed to the tribunals for the former Yugoslavia and Rwanda, these tribunals are called hybrid and internationalized because they are a mixture of national criminal law and international crimes. Also, instead of being located far away from the site of the armed conflict, they are situated, or if they cease to exist, they were situated in the countries where the contact at hand took place. And their staff was not only international, but they had people from those countries participating in those tribunals. Therefore, they were hybrid in that they mixed national and international criminal law, and that their staff was both national and international. But all of these tribunals were ad hoc with the objective of focusing on a single conflict. Following the establishment of the ad hoc tribunals for the former Yugoslavia and Rwanda, there was what we call a tribunal fatigue, especially the international tribunals, the ICTY and the ICTR, were hugely expensive. They took too much time, too much money and effort of the United Nations, on the part of the United Nations to run. The hybrid and international tribunals provided for a more flexible solution to dealing with atrocities committed in different countries. But at the same time, there was a growing recognition that the commission of international crimes entailed individual criminal accountability, and that they should not always expect to set up a new tribunal to deal with a specific conflict, with a specific situation. Therefore, after long negotiations, the International Criminal Court became a reality. The Rome Statute of the International Criminal Court was adopted in 1998, and it came into force in 2002, and since then the ICC has been operational. Now, it is important to clarify that the ICC is not superior to the other tribunals. What is different about it is that it is the first permanent tribunal of its country. Unlike all the previous war crimes tribunals, it is a permanent tribunal which does not focus on a single conflict situation. Potentially, it can deal with any conflict taking place around the world if the requirements are met. So let's talk about this a bit more. Now, the ICC is a permanent institution established by the negotiation and adoption of a multilateral treaty. That is, a treaty negotiated between a large number of countries. What crimes come within the scope of the ICC? We have the crime of genocide, war crimes, crimes against humanity, and more recently, the crime of aggression. Now, the court has been operational since the 1st of July 2002. What does that mean? It only deals with crimes which took place from the 1st of July 2002 onwards. It does not have the power, it does not have the jurisdiction to deal with crimes which took place prior to that date. Now, what are the requirements in place for the court, for the ICC to be able to step in a specific situation taking place around the world? Now, in the first place, the ICC has jurisdiction if the alleged crimes take place on the territory of a state party, of a country which has become a party to the International Criminal Court. In the second place, even if a crime takes place on the territory of a country which has not ratified the Rome Statute, the jurisdiction were committed by state party nationals. Thirdly, even if a country is not a state party to the ICC, it can accept the court jurisdiction on an ad hoc basis, on a one-off basis. This is what effectively took place in Côte d'Ivoire. Lastly, even again, we have a situation which takes place on the territory of a non-state party by nationals of a non-state party. The court can exercise jurisdiction if and when the United Nations Security Council decides to refer, to send a situation to the ICC. And via this avenue, the ICC arguably has jurisdiction potentially to every single country around the world. This option was exercised twice to date. In 2005, we had the referral of the Darfur situation in Sudan by the United Nations Security Council, and more recently in 2011, we had the referral of the situation in Libya to the court. Now, the situation is slightly different when we talk about the crime of aggression, but this is outside the scope of this webinar. Lastly, an innovative aspect of the ICC is that it has complementary jurisdiction up against the national courts. All the primacy over the national courts. For example, the Special Court for Sierra Leone had primacy over the National Courts of Sierra Leone. With respect to the ICC, the situation is different. We have complementary jurisdiction. The court, the ICC, will only step in and exercise its jurisdiction when the courts are genuinely unwilling or unable to prosecute or investigate individuals. For example, if the national authorities are trying to shield individuals from prosecution, or if the national authorities and the national courts in particular have collapsed as a result of war, then the ICC may determine that the national courts are either unwilling or unable to prosecute or investigate individuals, and thus the ICC will step in to exercise its jurisdiction. Thank you very much.